I'd like to apologize. We thought we could eat that quickly, but apparently we could not in town. So on behalf of the commission, we apologize to the parties and to those in attendance. We will make sure that doesn't happen tomorrow. Judge Allred, you indicated you had some preliminary matter, something you wanted to bring up.
Yes. Please, the Chair of the Commission. In regard to the motion granting the dismissal of the counts 4 and 20, the Commission advised that they had granted and dismissed those counts. I would request that in regard to the other motion to dismiss, in regard to the John Clem allegations, the Commission reconsider that ruling because it was filed based on the exact same violation of Supreme Court Rule 4.170 subsection 4, under the same assertion that evidence also had been intentionally not turned over to me because of the 1-year time limit to bring these formal charges. And I ask this with all respect, that logically, if you dismiss one for that, how can you not dismiss the other for that same legal argument? So it's a purely legal argument, and I would ask you all to reconsider it.
Mr. Bando.
Mr. Kelly.
Mr. Kelly.
Your Honor, I'm not exactly sure what the rationale of the court was for dismissing 4 and 20, but at least our argument in response to 14 and 15 was the information that hadn't inadvertently hadn't been produced didn't provide any information as to the charge, the nature of the charge. All the information required in the Supreme Court rule was given to Judge Allred through the statements from the witnesses that formed the proof that we're going to provide, which is the statements from Kurt Stallard. He was aware of it. All it was just the official unemployment records indicating the amount and totals of the benefits received, which really aren't to the heart of the charge. The charge is that the allegation was that Judge Allred had requested the jailer not oppose the unemployment benefits for someone who was otherwise not entitled to them. All that information was provided. The rule was met, and we think the Commission was correct in its initial ruling denying his motion to dismiss those charges.
Judge Allred.
Just briefly in response to that, I know that you all probably haven't seen those 17 pages of documents yet, but one of the interesting things about those 17 pages of documents indicated that Mr. Clem had to actually appeal. He was denied his benefits the first time and actually had to appeal and have a hearing to get those benefits. That would have been an interesting thing for me to raise in my response if I'd been given the opportunity under 4.170 subsection 4 before I was charged under Supreme Court Rule 4.180. My position is that these Supreme Court rules are ironclad. They're rules there to provide me the opportunity to respond. And when I realized that documentation wasn't provided to me, it really didn't dawn on me until I realized that there was an order in place that said these matters had to be charged by February the 21st, 2011, it would be barred, time barred. And if you're going to Harlan, you're sending your investigator down to get documents from the jailer, particularly ones that have any documents really, with the rules written, but documents that you're going to use to charge me, at the very least, I should see them before I'm charged. At the very least, I should be given the written opportunity to provide evidence of my own. I mean, that's Supreme Court rule. That's not my rule. It's not my argument. I don't see any leeway there in regard to that, and particularly coupled with the obvious reason that it was not turned over to me was because if it had been turned over to me in mid-February, and I'm given the opportunity to respond to this, February 21st, 2011 was the drop-dead date to have these charges in there, and it's clear. This is not just a good faith, I messed up, I've got to put on the record. My position is this is clearly an intentional act because they're faced with the unwarranted choice of 1-year time bar for violation of Supreme Court Rule 4.170 subsection 4. You know, it's easier to I guess I assumed it was easier to wriggle out of a 4.170 subsection 4 violation than a time bar where an order was signed that had to be charged by the 21st. And my only point is that every time new evidence came up in this case, every time it came up, I was given an opportunity to respond to it. That's my Supreme Court rule, not a caveat of the prosecution or the committee. It's something the Supreme Court has required to be done. In this case, it was ignored. It was ignored in one that you dismissed, and thank God you saw that. It was clear. The other one is the exact same thing. 17 pages of documents that were used in the charge. What's so funny about it is the charging instrument, the charging document, specifically references material facts that were in those 17 pages and not in anything else that was given in regard to Kurt Stowers' testimony. And the standard is not, well, he had enough to file a response. That's not it. The standard is shall. And Black's Law Dictionary makes it very clear that shall means they shall do it. There's no option in it. And in this case, exactly what happened in this case, and it's not Mr. Mando's fault, and it's not Mr. Kelly's fault. They got into this after. They didn't even know about the violation until I brought it to their attention in a telephone conference or a conference of some kind. And my point is, that's what I'm here for. And, you know, the Supreme Court rule is what I have to follow. And the Supreme Court rule was established to give me that opportunity to respond to that evidence and use that evidence before I was publicly charged under Supreme Court Rule 4.180. There is no doubt that was a violation. My position is that that was done intentionally because of this looming drop-dead deadline of charging. But that's my position. Thank you.
Go ahead, Mr. Cole, briefly.
Judge, I was just going to say there was no intentional withholding of the information. The information is not relevant to the charge. We had no intention of even introducing this evidence because to us, the proof in this is through the statement, through the direct contact between Judge Allred and Mr. Stallard. We can agree that the evidence wouldn't be provided because we weren't going to use it anyways because we didn't find it relevant or material. The rule says the factual information that forms the basis of the charge is provided. That information was provided to Judge Allred. I think the rule's been satisfied.
Mr. Mando, as a matter of proof, so we can see where we're going, where is this going to be discussed? In other words, we need to resolve that issue, but if that's not what you're going to next, we can do it at a break.
No, I do not intend to cross-examine Judge Allred about that particular matter.
We will take a break before you do so we can revisit that.
Certainly, because I don't anticipate presenting any proof on that point, maybe even this afternoon.
Okay. All right. We will resolve that issue, Judge Allred, before they would ask you about those charges.
Thank you. I guess you want back on the stand now?
Yes, please, Your Honor. Thank you.
Judge, obviously you recall that you're under oath.
Yes, sir.
And to the extent, Mr. Chairman, too, to the extent we have to remind anybody it's hard for me to keep track, but the recusal in light of the break and lunch, I just want to make sure that the separation order is still in.
If there's anyone in here who could be a witness, they need to step out of the courtroom. I think everybody who's here I've seen all morning,
Okay.
so I don't
Thank you.
think
Thank you, Mr. Chairman.
Thank you.
Judge Allred, it's my understanding that on or about April 16th of 2008, that you filed a complaint with the Public Service Commission against Kentucky Utilities, alleging that they had unlawfully billed and collected from you for certain fuel adjustment charges for both you and some companies you have an ownership interest in. Is that correct?
Yes, over the course of years, yes. One of those companies would have been my old law office, Russell D. Allred, attorney at law, PSC. May I get up for just a second?
Certainly. Let me hand you what I marked as Exhibit 16.
Yes, sir.
Is that a copy of the complaint you filed with the Public Service Commission?
Yes, it is.
All right. And am I correct, Judge, that that was filed on April 16th of 2008, correct?
According to the stamp on it, says received April 16th, 2008, so I would assume that's correct.
Then it's my understanding, Judge, that at some point after the complaint was filed, sometime later in 2008, that you had a conversation with counsel for Kentucky Utilities about your complaint.
I guess. I'm trying to remember which conversation you're having. I think we actually had a couple of them.
Okay. Let me show you, because I think this will help
Yes, sir.
clarify the matter here. Let me show you what I've marked as Exhibit 17
Yes, sir.
For purposes of explanation, this is the letter that identifies by paragraph number the allegations. When you did your response, you responded by that. That's not the charge number, and that's the only reason I attached that is for purposes of explanation.
Let me look at that if you don't mind, Councilor. Thank you very much.
What is Exhibit 17 then?
Exhibit 17 is a part of Judge Allred's response to the charges.
Thank you.
I would object to this coming in as an exhibit because the additional allegations that were listed in there were dismissed in the informal stage, which are confidential pursuant to the Supreme Court rule. So, you know,
We can
deal with that later? Okay.
We can do that. I will agree to redact it. The only thing I'm concerned about is your response
Yes, sir.
to the allegation about the complaint and how it was resolved with Kentucky Utilities.
Yes, sir.
Which is referred to as allegation 16 on the document.
Yes, sir.
Okay. And I'll agree to redact that. Anything else that's below that or above?
I don't have a problem with you just admit allegation 16 with that on there, as long as you don't attach the sheet that has a bunch of other
That's fine. We can take
matters
that
that were
off.
dismissed in the preliminary phase.
And the only reason I did that, Judge, was for purposes of, at the time, the numbers were aligned, and I didn't want anybody to think that was charge 16. It wasn't. It was just for a reference point.
Yeah, because they were different allegations over time and different numbers, and I understand that. Yes, sir.
But in your response, which you sent to the commission with regard to the charge having to do with the contribution made by Kentucky Utilities, tell me if I'm reading this correctly, that you, number one, I did file a personal complaint against KU as a private citizen because I felt that they were improperly billing under a fuel adjustment clause. I feel that I had a valid claim. As an agreement between the parties to resolve the matter, I agreed to dismiss my personal claim in exchange for KU making a $12,500 donation to the playground project at James A. Kaywood Elementary. Did I read that correctly?
Yes, that was my response. Yes, sir.
And when you entered into this agreement with Kentucky Utilities, it was done through a conversation with their counsel. Is that correct?
To the best of my knowledge, Mr. Mando, this is one I really don't remember a whole lot about because it wasn't a long period of time, but obviously there was some type of agreement. Yes, sir.
Right. And what I'm asking, Judge, is whether or not you recall having a conversation with the attorney for Kentucky Utilities where this agreement was reached.
I remember a conversation with the attorney for Kentucky Utilities telling him that it was my desire to go ahead and dismiss this action because it became clear after I had gotten into this that KU was going to have about 200 or 300 attorneys on staff to battle me in regard to this. This action was initially filed as a result of the Franklin Circuit Court issuing an order striking down the fuel adjustment charge clause that KU had been using and other utilities had been using in their electric bills, which ever since I was a younger man in private law office, really did not like a fuel adjustment clause. I thought it was unfair to citizens that a utility could simply raise the rate of a electric bill solely on their whim, particularly when I was in a coal-producing county and knew that all power plants and utilities had long-term contracts with coal companies to where the price of coal never really fluctuated in those contracts. But it was always amazing to me that on your electric bill it would fluctuate on a monthly basis regarding fuel adjustment charges. So I, as a private citizen, when I saw on television that the Franklin Circuit Court had issued a ruling striking that down, immediately filed my complaint, and or soon thereafter, and hoped to try to get some vindication for that. It became obvious to me that it wasn't going to pan out because I didn't have the time or the resources to deal with it. And I did talk to, I'm trying to think, what was the gentleman's name?
J. Kendrick Riggs?
You know, I can't really remember if it was
At Stoll, Keenan, and Ogden?
I can't remember. All the big firms just kind of run together to me. I used to work in Lexington, and I used to know him well then when I was a runner, but I can't remember. But anyway, he was a nice gentleman, and he was a reasonable person. There are actually three lawyers, I think, in this thing, if I'm not mistaken. And I had indicated that I was going to dismiss my claim, and I did mention to him that there was a playground project for the children in this area. KU had a lot of bad PR because of the electric bills being $500 and $600 that winter before that. There was a public outcry for that issue, and I did say that I would dismiss it if they would consider making a donation to that. There was no signed agreement to that effect or anything of that nature.
And I assume that the conversation you had with the KU attorneys, they knew you were a sitting judge in Harlan County.
I never told them that I was a sitting judge in Harlan County. I never used that statement. I never filed it as a sitting judge. So if they knew I was a sitting judge, it would have been through their own own investigation, because I never told them that I was a sitting judge, and when I filed my complaint, I filed it as Russell D. Allred.
Kentucky Utilities does business in Harlan County, correct?
Yes, sir.
All right. And I assume from time to time their lawyers would be down in Harlan County defending suits or representing them in Harlan County?
I don't remember ever a time having a KU case in front of me that I can recall.
And when you were in practice, Judge, as a lawyer,
Yes?
how would you have felt if a judge called you and asked for a contribution to a particular cause?
I've never had that happen, sir.
When a judge, did you ever have a judge call you and ask you to do him a favor when you were a lawyer?
I had Circuit Judge Ron Johnson one time try to force me to sign an affidavit in a judicial complaint that was filed against him. And then he recused in all my cases and made me travel for 2 years. I had that happen one time. And his lawyer, the defendant in the Judicial Conduct Commission, practiced in front of him for a year. Simultaneously, never disclosed it to anybody. So, yes, I did have that happen to me one time.
Do you feel, in your capacity as a circuit court judge,
Yes.
that if the attorney who you're negotiating with hears you ask for a $12,500 contribution to the James A. Kaywood Elementary School playground equipment, that he might feel somewhat compelled to do that because of your position as circuit court judge?
No, sir. I did not. That was never even an issue. I don't think that the attorney ever even mentioned that. Quite frankly, if you want me to tell you what I think KU was looking for some good PR in the Harlan area because there had been a huge outcry of high electric bills on very poor people. And as you'll note, in the picture I did in my opening, KU got a prominent space on the donation sign. I remember no discussions. And it really wasn't a quid pro quo type arrangement. It was one where I would dismiss it, and they were excited about the idea of good PR for KU and helping some kids out that wanted a playground. So that's the way I remember it. And I was more than tickled to waive any right I had to give these children a playground, sir.
And just so I'm clear, though,
Yes.
in your written response to the commission, you said an agreement had been reached between the parties to resolve the matter. You agreed to dismiss your personal claim in exchange for KU making this donation to the playground project at James A. Kaywood. That's what you put in your written
I
response.
put that I did agree that I would dismiss it if they made a donation. But however, before that started, that was the discussion we had. It wasn't a quid pro quo that they dismiss it or give a donation or I won't dismiss it. I was dismissing it regardless of that.
And independent of Kentucky Utilities and the contribution you secured from them to James A. Kaywood Elementary School for the playground project, it's my understanding that you solicited other individuals and businesses in Harlan County asking them to contribute to this worthwhile project at the school.
Yes, Mr. Mando, I did unknowingly solicit, unknowingly knowing that it was wrong, unknowingly thinking it was wrong, solicit donations for a playground for these children. Yes, sir, I did. As a parent.
Right, because your kids went to school there and your wife works at that
I had
school?
one child that went there, and quite frankly, James A. Kaywood Elementary School was the only school in Harlan County, period, that did not have a playground. The school used to be a high school. In fact, I graduated from that high school in 1990. That school being a high school had no playground on it. And quite frankly, the school district in Harlan County don't even have enough books for the kids, and there was no way these children were going to have a playground. And several parents got together and said, hey, you know what, guys, it would be a good idea for us to get these folks a playground. Me, not knowing it was wrong, went ahead and helped them raise money for a playground. I wasn't the only one that raised money for a playground. And I did contact people that when I was in private law practice, for instance, Darby Bennett, when I was in private law practice, he came to me numerous times asking for donations to the Boy Scouts, and I don't know how many times I donated money. I didn't really think it was a big issue, and I did it. I did it for this playground, for these children, and I've never denied that throughout this, sir.
And I understand that to be a worthwhile project, that there is a need for playground equipment at James A. Kaywood.
Yes.
However, when you contacted these people, they knew you were a circuit court judge in Harlan County, correct?
There is no doubt in my mind that the people I talked to knew that I was a circuit court judge because they probably had voted for me and known me all my life. Yes, sir. Whether I was a judge or not, they would have donated money to the playground project. There's no doubt in my mind.
Now, at some point, Robin, you became aware that Robin Teschon was working as a substitute teacher at James A. Kaywood Elementary School, correct?
Yes, sir.
Right. And in 2009, it's my understanding that Ms. Teschon was charged with a count of insurance fraud
Yes, sir.
In Harlan County, correct?
Yes, sir.
All right. Then at some point, you had a conversation, did you not, with Mr. James Clem, the principal at James A. Kaywood Elementary School, about Ms. Teschon?
I had a very brief conversation with James Clem, the principal of James A. Kaywood High School, wherein I simply advised him that one of his substitutes was under felony indictment in circuit court.
And did he tell you at that time that he knew she was under indictment, that she had disclosed that to the school administration staff?
Absolutely not. He never said that at any time.
Did you at any point in time ask him not to use her as a substitute teacher at that school?
Absolutely not.
Did you ever recall him telling you that he had checked with the superintendent, and since she had not been convicted, there were no school board policies that prevented them from employing her as a substitute teacher at that school?
In passing, subsequent to my initial conversation, he had a brief conversation with me indicating that he was going to continue to call her as a substitute. I made no comment. I was not angry, and I simply went on. I didn't even go and talk to him. He came to me trying to tell me that. And I very briefly went on about my way.
All right, so he told you that he was going to continue to use her as a superintendent at the, as a teacher at the school, and she was a substitute.
Yes.
Then, in late 2009, I think end of December, Ms. Teschon's case came before you in circuit court?
It had already, Ms. Teschon's case, Ms. Hensley, Robin Hensley Teschon, her case had actually come in front of me on an arraignment previous to that, and that's the only reason that I had known that she was under indictment. Subsequent to that, I saw her in a classroom after school with some very young children and advised the principal that she was under indictment, very briefly. I cannot remember if Mr. Clem, James Clem of James A. Kaywood Elementary School, told me before or after she came in front of court. I mean, I'm thinking it was sometime after that he indicated that briefly that he was going to continue to call her as a substitute, which I never made any comment to him in regard to that. To be honest with you, I think it was after that he mentioned it to me that she came back in front of me in court and I set the bond condition. I'm not sure, but I think it was.
Let me show you Exhibit 18. This
Yes, sir.
would be from a December 10, 2009 docket
Yes.
in which Ms. Teschon's case was called.
Yes.
And as a condition of bond at that hearing, you wrote on there, do not substitute teach?
Yes. The bond condition was do not substitute teach until your felony indictment is resolved. Yes.
And obviously then, the conversation with Mr. Clem where he told you that he was going to continue to use her as a substitute head teacher at James A. Kaywood Elementary School had to occur before that December 2009 court appearance. Otherwise, there would have been a violation. She would have been in contempt by working at the school, or a bond would have been revoked.
I don't follow your logic, Mr. Mando, because I would have set the bond condition whether the principal called her or didn't call her, because that's not the only principal in Harlan County. There's I'm thinking 19 other schools in Harlan County where you could substitute teach. So the bond condition would have been set for her just like it was anyone else in the courtroom that day. Quite frankly, I was amazed that people under felony indictment were being called to substitute teach in a position of trust, regardless of what the felony indictment was, particularly in regard to a fraud charge. So I thought that was the most reasonable thing to do until this felony charge was resolved, which it was at a later date.
But at some point, I want to show him clear. Did Mr. Clem tell you that he had conferred with the district office and there was nothing that, under the school board policies, that prohibited him from using Ms. Teschon as a substitute teacher at James A. Caleb Elementary School just because she was indicted.
Mr. Clem would talk to me very briefly. Mr. Clem hates my guts to this day. He told my sister-in-law that he would do anything he could to have me destroyed. Mr. Clem did not have any long conversations with me that I can ever recall. What I recall in regard to this, as a matter of safety, I notified the principal very passingly, and quite frankly, when I told him about this, he seemed to be very shook up about it. However, it is my belief that there's something wrong with him mentally, so I don't know if it registered. But my point is, the second time he mentioned that to me, he came running up to me, and I was simply trying to get down to pick my child up from school on that day and stay away from him. And the point is that it was just something, he's going to continue to call her, and that was the end of it. And I kept right on going. I don't even remember if I said yay or nay. I mean, I really didn't want to have a whole lot of discussion with him about it, and he really came up to me kind of odd about it, but I just kept right on going and didn't really talk to him in regard to that matter. But Mr. Clem, when I first told him briefly that this person was under indictment and she was watching children, she was substitute teaching at his school, he seemed very, very glad to have heard that. And that was the end of the conversation.
At some point, while you were sitting as circuit court judge in Harlan County,
Yes, sir.
were you receiving complaints about poker gaming machines at gas stations that were owned by James Howard?
Yes, sir, I was.
And can you tell us what the nature of those complaints were that you received?
It would usually be a very poor person. They would call to say that, because, you know, people in Harlan County or any other county in rural Kentucky, they don't understand the difference between a judge and a police officer or whatever it is. And I don't know if any of the judges try to go to Walmart, but good luck in my area. My point is, they would call and they would have messages or leave messages, or they would tell you, catch you when your secretary's out when you answer the phone. They would be crying that their husbands had gone over to gas stations in Harlan and put all the disability check in a poker machine. They had no money to pay their electric bills, and they had no money to pay this or that, and I would always refer them on to law enforcement. It seemed to be something that was going on continually, over and over again. And I felt, in regard to Canon 1, that I needed to report that on to law enforcement, that they had called and made complaints. And that's what I did.
And so were they telling you these complaints you received about these poker gaming machines at gas stations owned by Mr. Howard?
I don't think they specifically said Mr. Howard. I think they said, the quote would usually be, them poker machines is killing us. We don't have any money to pay our bills. I mean, something along that line is the usual complaint I got. And my husband or my man or whoever, their daddy would be a phrase they would use, is blowing everything we got on poker machines.
And you knew, Harlan County being a small county, small community, that these poker machines were located in the gas stations.
That is what the complaint was, and
you knew that Mr. Howard owned those gas stations.
I knew Mr. Howard owned some gas stations, quite a few of the gas stations in Harlan County.
And you knew that some of the gas stations he owned had these poker gaming machines in them.
I'm trying to think. I know that the complaints came in about the poker machines, and these were the video poker machines, I think, is what they were talking about. Mm-hmm. I think there might have been a time that I did see one of the poker machines in a gas station, yes. At Browning Acres, yes, I think so.
And these complaints you received, were they telling you a little bit about how these things were working such that it was illegal?
Well, I'm not sure, Mr. Mando, but I know the governor did put a lot of effort into trying to get gaming legalized in Kentucky when I watched it on television. I don't think it happened. And in Harlan County, poker machines, I really don't understand how you can play a poker machine and be legal in Harlan County. I don't understand that.
So in addition to, if I understand correctly, Judge, that in addition to referring the people that were calling you to complain about these poker gaming machines to law enforcement, in addition to that, you contacted the Kentucky State Police about the matter, correct?
Yes, sir, I did. I felt under Canon 1, I had a duty to report it to law enforcement.
And you
just as if someone had called me and said a child's been raped or someone's been hurt, or like I would do. Yes, sir, I did.
And when you contacted the state police, you urged them to investigate these particular allegations that you had heard.
Told them I had numerous calls, and I got calls all the time, and it was my desire to report it to them. And, you know, if I'm getting these calls all the time, I would tell them when I get calls. Yes, sir.
All right. And did you tell the investigator with the state police that you wanted them to look into the matter and that you wanted to have these poker gaming machines seized?
The investigator. Now, who are you talking about when you say the investigator?
State trooper. I'm sorry, I just used investigator.
My understanding,
as a
the
generic
case officer was Detective Keith Hensley, who gave a statement that he had never talked to me about this other than to have a search warrant signed and a destruction order signed subsequent to the agreed order of dismissal. So, I mean, I don't remember ever having conversations with Detective Saylor in regard to this, and he obviously didn't say it didn't happen. So I don't.
Did you have a conversation with the Jerry Bailey?
Jerry Bailey was the captain at Post 10 at the time. Yes, I did contact. That's who I made the complaint to, was Captain Bailey. Yes, sir.
And during the course of that conversation, you wanted the state police to look into these complaints that you had been receiving from citizens in Harlan County.
Reported it to the Kentucky State Police, and I found the Kentucky State Police to be a very honorable profession, an honorable police agency that does their job well. And normally, when a citizen makes a complaint to them, or a judge advises them of citizen complaints, they investigate those complaints very quickly. Yes.
All right. Well, if that's the case, and if they look into these and they're pretty efficient, look into things quickly, and you referred the complainants on to the state police, why did you call too?
Because, as I said, under Canon 1, I felt I had a duty to report criminal conduct to the police agency.
And did you, during the course of your conversation with Jerry Bailey or anyone else affiliated with the Kentucky State Police, urge them to seize these poker machines from the gas stations?
I don't recall telling him to seize poker machines from gas stations. I don't recall telling him that, no.
Did you recall asking him that they need to take the machines?
I don't recall telling him that either. I recall reporting to him that I'd received numerous complaints. These complaints came in all the time, and I was reporting it to him. That way I made sure that I could say, if somebody asked me, did you report these? I reported them to the head person at Post 10 in Harlem.
Did you ask him to take any action?
I reported the criminal complaints to him, and I would assume he's going to investigate those complaints.
In the conversations you had with him, did you ask him or suggest to him that he take any type of action?
I don't understand what you're saying, Mr. Mando.
You're indicating, I just want to make sure I'm clear in terms of what you recall about this conversation or conversations with state police. And I understand you're saying you reported these complaints to the state police.
Yes, sir.
What I want to know is, in addition to reporting them, did you also tell them or ask them to look into the matter, to investigate it?
I don't recall, if you're asking that I say, you guys better check on this, I don't recall ever saying that. I recall contacting Post 10 and asking to speak to the captain so I could advise him that these complaints had been coming in to me. Mm-hmm. The citizens had called often, and I simply told him what they had told me and reported on to him like I thought I had a duty to do as a circuit judge or any judge in that matter.
Did you render an opinion to the state police that you thought these gaming machines were illegal under Kentucky law?
I don't recall ever rendering an opinion to that effect. I don't know. I guess my position on that issue isn't it pretty self-explanatory? Is gambling legal in Kentucky?
I'm just asking, Judge, what you recall about these conversations and the best of your ability to tell me the details of those conversations in terms of what you said to the Kentucky State Police and what you may have asked them to do. That's all I'm asking.
What I recall, Mr. Mando, is reporting to the captain at Post 10 at the time, Captain Bailey, who's a very nice man, that I'd received numerous complaints. That's what I recall. I recall telling him what the complaints were, and I recall feeling relieved that I had made that referral. Now I felt I had done my duty. If there are other things that went on in that conversation, I don't remember them.
And do you also recall having any similar conversations with the Harlan County Sheriff in 2008, asking him to look into these poker gaming machines?
No, I don't recall ever having a conversation with Marvin Litford.
Any of his deputies?
I don't recall having a conversation with his deputies. That's the reason I reported to the captain at Post 10 is because, to be quite frank with you, I felt more comfortable with the captain at Post 10 than I did Sheriff Marvin Litford.
Even back in 2008?
back in 2008. If I'm not mistaken, that's right around the same time period that the sheriff brought Bill Ball into my office. So there was starting to be a little bit of issues with him at that point.
All right. And then it's my understanding that as a result of the investigation that was done, that Mr. Howard was indicted on a conspiracy to promote gambling charge in November of 2008.
Yes, sir.
And you presided over that case in Commonwealth versus Howard, correct?
I signed the indictment in the case, and I signed an agreed order of dismissal in the case, yes.
So, yes, you presided over the case, correct?
That's what I did, yes.
And did you feel at that point that there was any reason for you to recuse, given the fact that you had contacted KSP about these gaming machines and the complaints you had received?
At the time, the way I understood the rule is that was in my official capacity as a judge if someone calls my office and made a complaint and I referred it on. I thought that's what the official capacity meant as a judge. I thought that's what I was supposed to do. I didn't have any long, in-depth discussions with these people about what went on, what store it was in, how much money did they spend, or anything of that nature. I felt that was part of my official capacity. And in addition, when the matter was presented to me on an agreed order of dismissal signed by Mr. Howard and the Assistant Commonwealth Attorney Sharif Gindy, I really didn't see what the issue was in regard to an agreed order of dismissal. The case was dismissed, provision in it being that it be dismissed with prejudice and allowed to be expunged. And I really didn't see, I'll be quite frank with you, I didn't see what the issue was at that point. And I may be wrong, but I did not see the issue at that point.
Exhibit 19,
Yes.
which is a certified copy of the records in the Commonwealth versus James Howard case. You can take a second page through those.
I'm familiar with it.
Okay. And part of that packet of records, there's the November 17th, 08 order dismissing the claims, dismissing the charge against Mr. Howard on the condition that the monies in the machines be forfeited and that the machines be destroyed, correct?
Yes, an agreed order said that, yes.
And that particular agreed order was entered in court with Mr. Howard present, correct?
Yes, sir, it was.
But he was represented by counsel at the time, Mr. Doan, correct?
No, I was not aware of that.
You had no idea that he was represented by counsel?
No, sir, did not.
This hearing that you had with Mr. Howard was conducted without counsel being present, correct? For the defendants.
Give me just a second.
The November 17th, 08
Okay.
order.
Bear with me just a second. Are you talking about the agreed order?
The agreed order of November 17th, 08.
It reads as follows. The November 17, 2000, this matter having come before the court and the parties having agreed, and the defendant agreeing to forfeit all gaming machines, all money inside said machines, and all the money seized in above said case, and the defendant agreeing to refrain from illegal gambling activity in the future, and the defendant understanding his constitutional rights and waiving his right to counsel, and the Commonwealth agreeing to dismiss the above style case with prejudice in 6 months' time if the above terms are followed, and the court being sufficiently advised, it is hereby ordered a judge that this above style case is dismissed without prejudice, and that all gaming machines and money seized herein shall be forfeited. Agreed to and distribution, James F. Howard and Sharif Gindy, Commonwealth Attorney's Office. Right. Yes, that's the order. And that's my understanding was that he waived his right to counsel after talking to Sharif Gindy, the Commonwealth Attorney, Assistant Commonwealth Attorney. And my understanding was Sharif Gindy, Commonwealth Attorney, drafted that order.
Had you ever known you knew Mr. Howard obviously before that day, correct?
Yes, I grew up in Loyal, Kentucky. Mr. James F. Howard is from Loyal, Kentucky, just like my mother, my father, my aunt, my wife. For many years, James F. Howard was a person who had supported me in a district judge campaign and liked me years ago. And yes, I knew Mr. Howard.
In addition to presiding over the case involving Mr. Howard that we just identified in November of 08, am I also correct that you presided over a case involving Commonwealth versus Wallace Smith and that you sentenced Mr. Smith?
Yes.
All right. Now, Kotha Hudson, she is an attorney licensed to practice law in the Commonwealth of Kentucky, to the best of your knowledge?
I have no idea whether she's licensed or not.
When she appeared before you in the Harlan Circuit Court, did you understand her to be a lawyer licensed in the Commonwealth of Kentucky?
Mr. Mando, to be quite frank with you, I don't know if she had a license or not.
Did she represent that she was a lawyer when she appeared before you representing clients?
I'm not trying to be difficult. I'm just simply saying I don't know if she did or not. But now I can say this to you. She did come to court. She was brought in by the DPA's office as a conflict attorney to cover conflict cases in Harlan Circuit Court. And she did make appearances for people on occasion, yes.
And it's my understanding that she was brought in by DPA. She was assigned the defense of indigent defendants who qualified for a public defender, correct?
Hold on just a second. You asked me the question again. I'm sorry.
I'm sorry. Ms. Hudson was assigned cases for indigent defendants who qualified for public defender on criminal cases in Harlan County.
That was my understanding of what a conflict counsel is for the DPA, yes.
And it's my understanding that over the course of some time, particularly perhaps in 08, maybe 09, a little bit to 08, that there was a problem with Ms. Hudson showing up in your courtroom. She wouldn't show.
Absolutely.
All right. And then let me show you what I've
Not just showing up for court. I'd received numerous complaints from defendants who were incarcerated indicating that she wouldn't come and see them in jail, she wouldn't return their calls, and they're languishing in jail. And I'm a circuit judge with a 250, 260-person docket trying to keep these folks moving as fast as I can while protecting their rights. So that's what I was confronted with Ms. Hudson.
Let me show you what I want to just exhibit.
Yes, sir.
You recognize that order, Judge?
Yes, sir, I do.
Right. And that's an order that was entered in February of 2010 in the Harlan Circuit Court, in which you have relieved Ms. Hudson as attorney in, I don't know, what is there, 15, 20 cases listed there, ballpark?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24 cases, what it appears to be. Yep, looks like that's what it was, 24.
24. All right, thank you, Judge.
You're welcome.
And in addition, you instructed DPA that she was not to handle any further criminal cases that came before they qualified for public defender in your court.
I think what I told them was, and please bear with me on this, Mr. Mando, a lot of this stuff has been several years ago, but in regard to Ms. Hudson, I think I told them there was no sense in sending her back to Harlan, not to send her back to Harlan Circuit Court to cover cases, because she wouldn't show up. She was either perpetually sick, the roads were always bad, but all the attorneys from Bell County and Middlesboro seemed to make it just fine when they'd come to court, but she was always snowed in on the side of a hill in Middlesboro. I have family in Middlesboro, and I've lived in the mountains all of my life. Yes, I relieved her of those cases because these defendants, their Sixth Amendment right to counsel was being violated is the way I felt about it. I don't see how I can sit on the bench as a judge and comply with the canons of ethics if I see an attorney leaving criminal defendants languishing in jail time after time coming to court and not showing up. And I felt that I had no choice but to relieve her as counsel and ask Linda West, direct Linda West, who is the managing attorney for the Bell Harlan Public Defender's Office, to get me somebody up there that would represent these defendants so we could get their cases moving. And that's what I felt that I had to do in regard to this case.
And it's my understanding, Judge, that you entered that order that we've marked as an exhibit.
Yes.
You entered that order without any advance notice to Ms. Hudson and without a hearing where she could present a defense or state her case. Is that correct?
That's not correct, and I'll tell you why it's not correct. I told Linda West, the managing attorney down there, I don't know how many motion hours I've told her. If you look, and I'll do this when I testify in my side of the case, you'll see that Ms. Hudson has a horrendous record of not just my court, every other court that she's been in, and even through her own employment with the DPA, of not showing up for work, not showing up for court. warnings mean nothing to Ms. Hudson. In fact, the prior judge, the one that hated my guts and has no reason to try to help me out, he'd actually issued an arrest warrant for her for not showing up for court. I was faced with the position of, do I issue a show cause order, let her come to court, put her in jail with 24 criminal defendants? I put their lawyer in jail, and the only time that they get to talk to her when she's sitting in an orange outfit up at the detention center, then they can talk to her. And then, after I let her out of jail, bring her back down there and put her out with these defendants to try to defend them. How do you think a defendant would feel about their chances of a fair shake in the criminal justice system if that's what I did? So the reason I did what I did was to protect the Sixth Amendment rights of these defendants, get them an attorney, which the public defense DPA has a statutory duty to do for these defendants. I can't have a show cause hearing if she never shows up to be there, to have a show cause hearing.
And Judge All, I'm not defending Ms. Hudson. I'm not arguing with you about the rationale for taking disciplinary action that a judge has to take in order to run his courtroom. What I'm saying, though, is before that order was entered, did you give advance notice to Ms. Hudson that you were going to relieve her from those cases? And did you give her a hearing where she would have an opportunity to present her side of the case? Yes or no?
I gave advance notice to her supervisor, Linda West, the supervising attorney at the DPA. Yes, I did.
And in terms of the impact of your order, the impact of your order is that Ms. Hudson has basically been suspended from the practice of law in Harlan County.
No, sir. That's not true.
She's not permitted to handle criminal cases in your court by virtue of your order and directive, correct?
She cannot do DPA cases as a conflict attorney in front of me because she won't show up for court. Now, she can go to Harlan District Court. She can come up there as a private attorney all she wants to if people want to hire her. But the DPA has a statutory duty to provide a defense for a criminal defendant who is indigent. How on earth can I sit back and let DPA say that they've done their statutory obligation by hiring an individual who will not show up for court, who will not defend these people, who let them languish in jail? How could I possibly sit there as a judge and do that? And my answer to you is, yes, she can practice law in Harlan, but I will not allow the DPA to not comply with their statutory duty that they are state funded to do, and this individual received a lot of money to defend these people and did not show up for court. I will not allow that go on because the DPA is ultimately responsible for her actions because she's their conflict attorney. And I relieved her as the conflict attorney, not the DPA. And if you note in this order, I say clearly, it is ordered and directed that Honorable Linda West has until March 4th, 2010 to appoint new conflict counsel for the above criminal cases. And she did, and she brought a fellow named James Wren in, and he is the most, quite frankly, one of the finest attorneys I've seen practice in front of me. He's cleared these cases out. He's tried a rape case where an individual was acquitted. He brought out a social worker who was lying in that case, and quite frankly, it's the best thing could have happened for the defendants, for this individual to be relieved as counsel.
Mr. Chairman, may I have 1 minute, please, to confer with counsel?
You may.
Judge, Mr. Chairman, that'll conclude my cross-examination of Judge Allred. I would move the introduction of Exhibits 1 through 19.
Judge Allred?
I would renew my objection to Exhibit 18 because of the confidential dismissed allegations in the preliminary phase of this matter. So if he can either redact or take the cover page off, whichever one he would like to do, that's okay with me in regard to that.
I'm sorry, I may have misspoke. Did I miss an exhibit? I thought I had 1 through 19.
20.
You don't
I understand it.
You don't want 20 in.
Yeah.
20.
It's 17.
And I agree. We can take that cover letter off
This one.
and
17.
on 17 and remark it, if that's okay with the judge.
That's fine with me.
What
No
about,
problem.
there were 20 exhibits discussed.
What was number 20?
Right there.
The order, okay, yes. I'm sorry, Exhibits 1 through 20, I missed it. my notes weren't correct. So I'm moving exhibits 1 through 20. Please read mark this.
Yes, sir. Take your time.
Judge Allred, any other?
You know, let me say this, Mr. Chairman, and it's kind of an odd situation because I'm also my own counsel. Normally, I would have got the opportunity to cross-examine the witness and do my exhibits in regard to this. I would like to reserve that right to do that until my case, side of the case, if that's okay. I want to make sure, that's one of the reasons I wanted to go second as opposed to going first, because you see it's kind of
What, do you have a specific objection to any of those exhibits?
Oh, I'm sorry. I thought you were asking about that, Mr. Chairman. Forgive me because I've been testifying simultaneously. Oh, I would like to add, if I can, just one thing before I go in regard to exhibit number 19. Just a couple of points of clarification before I go. Exhibit 19, there's been an attachment of an order of recusal by me in this case. And the reason I subsequently recused was, in Mr. Howard's case, there was a motion to dismiss with prejudice that was filed. And by that time, Mr. Howard was part of the allegations, I think, against me at that time. So I recused in the case at that time. But in any event, no, I have no objection to him going in with the redaction. Can I ask Mr. Mando something, though?
Certainly.
So,
We'll admit then exhibits 1 through 20 with the redaction.
It's already been taken care of, Mr. Chairman.
All right, and that concludes your examination of Judge Allred?
It does.
All right. Who's your next? I'm looking at it from a time standpoint, Mr. Mando. How long would you expect your next witness to be on the stand?
Direct examination, 30 to 45 minutes.
Let's take a quick break then. We'll break at this time. We'll take a 10-minute break. Judge Allred, did you have something?